I sat in a family courtroom 2 years ago, listening to my own daughter tell a judge, under oath, that she didn't believe I was fit to supervise my grandchildren unsupervised, citing my age and what she described as concerning lapses in judgment during a custody-adjacent visitation dispute with her ex-husband. I remember the specific silence in that room, watching her avoid my eyes entirely, understanding that whatever led to this moment had apparently been building for longer than I'd recognized. I want to tell you what actually happened, both in that courtroom and in the 2 years since, because the concerning lapses she cited turned out to be something considerably more complicated than simple incompetence, and the resolution took me somewhere I never expected. I spent 38 years as a volunteer and eventually chief of my local fire department, a demanding but deeply meaningful career that let me remain rooted in my community while raising my own daughter, Patricia, largely as a single father after her mother left when Patricia was 7. When Patricia had her own 2 children, I became an active, regular presence in their lives. Weekly visits, occasional overnight stays, a role I took seriously and had, until this dispute, always believed I managed responsibly. I want to describe a specific weekly ritual that mattered enormously to me. Wednesday evenings, picking up both grandchildren for what we called fire station night, where I'd show them around the station where I'd once served, teaching them basic safety concepts in a way that felt, at the time, like meaningful continuation of my life's work, rather than simply babysitting. Patricia's divorce from her children's father had become increasingly contentious over the preceding year, disputes over custody schedules escalating into formal legal proceedings that eventually drew extended family members, including me, into testimony about various aspects of the children's care arrangements. I hadn't fully understood, before that specific hearing, that my own supervision capacity would become a contested issue within the broader custody dispute, assuming my role would remain peripheral rather than becoming a direct subject of testimony. I remember receiving the subpoena to testify with genuine confusion, initially assuming I'd simply be asked general questions about the children's well-being and family stability, entirely unprepared for the specific direction that questioning would eventually take once I was actually seated in that witness stand. Patricia's testimony centered on a specific incident about 4 months before the hearing, when I'd been watching both grandchildren for an afternoon and had, apparently, become confused about which child needed a specific allergy medication, momentarily giving the wrong child a dose intended for their sibling before catching the error within minutes. I remembered that incident too, though I genuinely believed, at the time, that I'd caught and corrected it quickly enough that it represented an understandable mix-up rather than any dangerous, systemic pattern worth escalating to formal legal testimony. I remember that specific afternoon clearly, the momentary confusion between 2 medication bottles that looked more similar than I'd initially registered, catching my error within perhaps 90 seconds when the younger child mentioned the medicine tasted different than usual. I'd told Patricia about it myself, actually, that same evening, genuinely believing at the time that honest disclosure of a quickly corrected mistake reflected responsible grandparenting rather than dangerous incompetence. I learned, during that hearing, that Patricia's ex-husband's attorney had specifically requested any evidence suggesting either parent's broader support system carried genuine reliability concerns, and that Patricia, under considerable legal pressure to present a complete, defensible custody position, had disclosed the medication incident as part of a broader pattern she was apparently required to address honestly under oath. I understood, intellectually, why she'd felt compelled to disclose it once directly asked, but understanding that legal necessity didn't fully soften the specific hurt of hearing my own daughter characterize me, in a public courtroom, as someone whose judgment required active questioning. I remember the specific words she used on the stand, concerning lapses in judgment, plural, a phrasing that suggested a broader pattern, rather than the single, quickly corrected incident I understood the situation to actually represent. I found myself, sitting in that courtroom gallery, wondering whether other incidents I wasn't aware of had also been mentioned, or whether legal language had simply amplified a single event into something sounding more systemic than it actually was. I left that courtroom deeply hurt, feeling that Patricia had prioritized her own legal position over protecting my reputation and our relationship, regardless of whatever legal pressure she'd genuinely been under. I didn't speak with her for several weeks following that hearing, a distance neither of us actively chose but that emerged naturally from the raw hurt on both sides, hers likely including genuine guilt about how the testimony had unfolded. I remember specifically cancelling our next scheduled fire station Wednesday, telling Patricia I needed some time, watching her accept that request without argument, likely understanding, even in her own difficult position, exactly how deeply the testimony had landed for me. Patricia called about a month later, her voice carrying genuine distress, explaining more fully what had actually happened during that hearing preparation. That her attorney had specifically warned her that failing to disclose known safety concerns, however minor, could be used against her own custody position if opposing counsel discovered them independently later. She told me she'd agonized over that specific decision, genuinely torn between protecting my reputation and protecting her own legal standing in a dispute where losing primary custody was a real, frightening possibility she'd been actively fighting against for months. I remember her voice breaking during that call, describing a specific late-night conversation with her attorney where she'd initially refused to disclose the medication incident at all, only relenting after her attorney explained, in stark terms, that opposing counsel discovering it independently later could be portrayed far more damagingly than her own controlled, honest disclosure up front. I spent time, in the following weeks, actually researching family law proceedings more generally, understanding better the specific pressures Patricia had described, learning that attorneys frequently do advise complete disclosure of any potentially relevant safety information, specifically to avoid more damaging accusations of concealment later in contentious proceedings. That research didn't erase my hurt entirely, but it did help me separate Patricia's specific legal strategy, driven by professional counsel under genuine pressure, from any broader judgment about my actual capability or her underlying feelings about me as her father. I remember reading through several articles, specifically about mandatory disclosure requirements in contested custody proceedings, finding case after case where similar dynamics had played out. A party, forced to disclose minor, otherwise private family information, specifically to protect their own legal position, often at real cost, to another family relationship in the process. Around this same period, already considering retirement after decades of demanding fire service work, I began seriously researching retiring abroad, specifically the Philippines, drawn by both genuine financial appeal and a desire to build something new following the emotional difficulty of the preceding months. I want to be honest that the courtroom experience, while resolving gradually through Patricia's later explanation, added its own quiet motivation toward this decision. A desire for distance that might allow both of us room to rebuild trust without the constant physical proximity to where the difficult testimony had occurred. Gah! I spent nearly 4 months researching carefully, treating the financial planning with the same methodical discipline I'd once applied to fire safety protocols across nearly 4 decades of service, verifying visa requirements, healthcare access, and cost of living comparisons before committing to any specific timeline. I moved 14 months ago, settling into a coastal retiree community and establishing genuine local routine, distance giving both Patricia and me space to process the courtroom experience without daily physical reminders of where it had happened. I also, during this period, took a specific safety refresher course locally, something I genuinely wanted to do regardless of the courtroom incident, ensuring my own confidence about medication management and general childcare safety had a concrete, verifiable foundation rather than simply my own self-assessment. I remember the specific pride I felt completing that course, a 2-day intensive program covering pediatric medication safety and general emergency response, applying decades of my own firefighting emergency training to a slightly different but genuinely related context. The instructor, learning briefly about why I'd enrolled, told me my existing emergency response background actually gave me advantages most course participants lacked, a small but meaningful professional validation during a period when my own competence had felt publicly questioned. Patricia visited with both grandchildren about 6 months after my move, our first extended time together since the original hearing, and I made a point of showing her the safety course completion certificate, not defensively, but simply as evidence of genuine, deliberate effort to address her original underlying concern directly. She told me, watching me interact naturally and carefully with both children throughout that visit, that seeing my continued genuine engagement, alongside the concrete safety course evidence, had done more to ease her remaining worry than any argument or explanation could have accomplished. I remember a specific moment during that visit, my grandson asking to see the fire station photos from his phone, both of us falling naturally back into our old Wednesday ritual conversation, despite the distance and time that had passed. Evidence, I think, that the underlying relationship itself had never actually been damaged, only strained by circumstances neither of us had fully controlled. We had, during that same visit, the fuller conversation neither of us had managed in the immediate aftermath of the hearing, Patricia explaining more completely her own guilt about how the testimony had unfolded, admitting she wished she'd found a way to discuss the medication incident privately with me, before it ever became part of formal legal proceedings. I told her honestly that I understood the legal pressure she'd genuinely faced, and that my hurt had never really been about the incident itself, minor and quickly corrected as it actually was, but about learning of her characterization secondhand, in public, rather than through a private conversation first. I remember her specific response to that clarification, a long exhale followed by genuine relief in her voice, admitting she'd assumed my hurt was purely about being doubted professionally, never fully grasping until that conversation that the deeper wound had been about process and dignity rather than her actual underlying assessment of my competence. Patricia and I established, following that visit, a specific new practice for any future difficult family matters. Direct conversation first, privately, before either of us allows any concern, however legally necessary its eventual disclosure might become, to reach the other person through any indirect channel first. I've noticed, in the months since, a specific deepened trust between us that I don't think existed even before the original hearing, both of us having navigated something genuinely difficult and emerged with clearer communication than we'd previously practiced. We tested that new practice recently, actually, when Patricia faced a separate minor disagreement with her ex-husband about the children's school enrollment, calling me directly first to discuss her thinking before any formal communication went to attorneys. A small but meaningful demonstration that our rebuilt communication pattern was genuinely functioning, rather than simply a well-intentioned promise made in an emotional aftermath. If you've experienced something similar, a family member's legal testimony that felt like painful public betrayal, I want to tell you what this experience taught me. Legal proceedings often force disclosures that reflect genuine professional pressure rather than the testifying person's actual private feelings or judgment about you. I'd encourage patient curiosity about the specific legal context once initial hurt has settled enough for genuine conversation, rather than assuming courtroom testimony automatically reflects someone's complete, permanent assessment of your relationship. I still keep that safety course certificate, now framed in my apartment here, not out of lingering defensiveness but as a genuine, positive marker of how Patricia and I navigated something difficult together and came out with a stronger relationship than before. If you're facing your own version of that courtroom hurt, I hope you find the same patient understanding I eventually reached, genuine curiosity about the legal pressures involved, and the willingness to have the fuller private conversation that should have happened before any public disclosure ever did. I'll see you in the next one. I want to include a moment from my youngest grandchild, my granddaughter, who was old enough during the courtroom period to have some awareness that something difficult was happening within the family, though she wasn't present for the actual hearing itself. She asked me directly, during a recent visit, why I'd stopped our Wednesday fire station visits for a while, and I gave her an age-appropriate but honest answer, that grown-ups sometimes have disagreements that take time to work through, and that her mother and I had needed some time before things felt normal again. She thought about that for a moment before responding, with the specific directness only children manage, that she was glad we'd figured it out, because Wednesday was her favorite day of the week when I was still living close by. That simple, unguarded comment reminded me more than any adult conversation had, exactly what had actually been at stake throughout that entire difficult period. I want to mention one final, somewhat unexpected piece of this story. Patricia's ex-husband, whose attorney had originally requested the disclosure that led to my difficult testimony, reached out to me directly about a year after the hearing, apologizing for how the proceedings had affected me personally. He told me he'd never intended for the custody dispute to damage my relationship with Patricia, and that watching the aftermath unfold, even from his position as the opposing party in the original case, had made him genuinely uncomfortable with how adversarial legal processes could inadvertently harm family relationships, extending well beyond the two parties directly disputing custody. I appreciated that specific acknowledgement more than I expected to, understanding that even someone positioned as an adversary in that original dispute had recognized the broader human cost the legal process had extracted, a cost that, thankfully, Patricia and I eventually found our way through together. I want to describe the specific moment we resumed our old Wednesday tradition, now adapted for the distance between us. A small but meaningful continuation neither of us wanted to let the courtroom experience permanently take away. We settled on a modified version, a standing Wednesday video call, where I'd show my grandchildren photos and stories from my actual working fire station days, gradually expanding into stories about local fire safety practices here that differed interestingly from what I'd taught them growing up. My granddaughter, particularly, became fascinated by the differences, asking detailed questions that reminded me of my own younger self, genuinely curious about the mechanics of safety and prevention. By the 6th month of these calls, my grandson mentioned, unprompted, that Wednesday had become his favorite day again, the same simple declaration that had once defined our in-person tradition, now finding new life across considerable distance. Evidence that the actual substance of what we'd built together had survived intact, despite everything that had happened. I want to describe how that original safety refresher course, initially taken defensively in the aftermath of the courtroom hearing, eventually became something considerably more meaningful than simple self-justification. About a year after completing it, a local community center here, learning of my extensive fire service background, asked whether I'd be willing to teach a modified version of that same safety course to other retirees and local families, adapting the material for a general audience rather than the specific childcare context I'd originally taken it for. I've now taught that course to over 60 people here, watching parents and grandparents alike gain genuine, practical confidence around emergency preparedness and childcare safety, a specific irony not lost on me, that the defensive credential I'd once earned purely to reassure Patricia had become a genuine contribution to an entire new community, considerably beyond its original narrow purpose. I asked Patricia recently, with some real distance now from the original hearing, whether she'd come to any further understanding of that difficult period beyond what we'd already discussed during her visit. She told me something that stayed with me, that watching me build genuine expertise and community contribution around exactly the safety concern that had originally driven her difficult courtroom testimony had helped her fully release whatever lingering guilt she'd continued quietly carrying. She said she no longer thought of that hearing as a wound in our relationship, but as a strange, difficult catalyst that had ultimately produced something neither of us could have predicted. My genuine new expertise and community role, built directly from what had once felt like pure, painful accusation. 3 years now since that original hearing, and I find myself teaching my safety course most weeks, maintaining our Wednesday video calls without fail, and hosting Patricia and both grandchildren for an extended visit at least twice yearly, a rhythm considerably richer than what existed even before the entire difficult chapter began. I think about that framed safety certificate on my wall sometimes, understanding now that it represents something more complete than simple vindication, genuine proof that painful, unfair moments can sometimes become the specific foundation for building something better than what came before them, provided you're willing to do the actual work of rebuilding rather than simply nursing the original hurt indefinitely. If you're currently carrying your own version of courtroom hurt, or any painful public accusation from someone you love, I hope you find your own version of what I eventually built, not just reconciliation, but a genuine, positive path forward that transforms the original pain into something that actually serves you and your community going forward. I'll see you in the next one.